Hello everyone. So Vice President of India, Mr. Jagdeep Dhankar, he has demanded for filing of FIR against the sitting judge of Allahabad High Court, that is Justice Yashwant Verma. The same Justice Yashwant Verma, when he was posted in Delhi High Court, a huge amount of cash was recovered from his official residence, and hence as a punishment he was transferred to his parent High Court, that is Allahabad High Court. But more importantly, what Vice President has also demanded is, he has demanded for Supreme Court to revisit K. Veeraswamy judgment of 1991. And hence in this video, what we are going to discuss is, what is this K. Veeraswamy judgment, why it is significant, and why there has been demand for revisiting this judgment. But before we understand this particular case, let's first try to understand the concept of independence of judiciary. So you see, judiciary has been given a very fundamental, very basic role of protecting the rights of the citizens, especially the fundamental rights of citizens. And hence, in order for judiciary to perform its duty effectively, it is very essential that judges, they are protected. If judges have not been given protection, they will be a victim of personal grudges or victim of vendetta from, let's say, litigants, from politicians against whom they have given judgment, and so on, right? And hence very high constitutional bar has been set against for judges to prosecute, right? In fact, in constitution there is only one way of punishing judges of higher judiciary, that is through the process of impeachment under article 124, right? Apart from it, there has been no punishment given for judges in India apart from article 124. But as you all must be knowing, that a process of impeachment, or through this process no judge has been removed till now in the history of independent India, and hence judiciary itself has also come up with one another mechanism, that is, if some serious allegations are made against a particular judge, what CJI does is, Chief Justice of India does is, Chief Justice of India forms one in-house committee. For example, in case of Justice Verma as well, a 3-judge in-house committee was created by Supreme Court Chief Justice, and that committee, it does its investigation, then submits the report to Chief Justice of India, right? Why we are using the word in-house? Because all the 3 members of this committee, they will be from judiciary only, right? So the committee, it submits report to CJI. If CJI finds, right, that the allegations made against the judges, there is some element of truth, then CJI might ask that judge to resign. Even if the judge doesn't resign, what CJI will be doing is, CJI will be forwarding the recommendations or the report of this committee to President as well as Prime Minister, right? This is the case, in fact, in the case of Justice Verma as well. The committee has found that the allegation made against Justice Verma are true, and hence they have recommended the CJI to recommend to the President for the process of impeachment of Justice Verma. Giving this reason, in fact, CJI has not allowed to file FIR against Justice Verma, saying the report is already with President as well as Prime Minister. Now let's try to understand what is the case of Justice Veeraswamy. So see, Justice Veeraswamy, he was the Chief Justice of Madras High Court, and when he was about to retire, some serious allegation of corruption were made against him, right? Because allegations of corruption were made against him, a case was registered under Prevention of Corruption Act by the CBI, Central Bureau of Investigation, right? So CBI filed a case against, or filed FIR against Justice Veeraswamy under Prevention of Corruption Act. But the thing is, Justice Veeraswamy challenged this decision of CBI of filing FIR against him to Madras High Court, right? The argument of Justice Veeraswamy is, or was, that whether CBI or any prosecuting agency is allowed to file a case against a sitting judge of higher judiciary, that is High Court or Supreme Court, aren't the judges of higher judiciary protected from these kind of prosecution? Madras High Court, it formed a 3-judge bench. This 3-judge bench by a majority of 2:1 decided that the filing of FIR by CBI against Justice Veeraswami, there is nothing wrong with it, and in fact any prosecuting agency under the laws passed by Parliament can file the FIR. This judgment of Madras High Court was challenged by Justice Veeraswamy into Supreme Court, right? So there were two very fundamental questions in front of Supreme Court. Firstly, whether the judges of higher judiciary, they come under the definition of public authority under Prevention of Corruption Act. So Prevention of Corruption Act says that all public authorities, they can be persecuted or prosecuted under Prevention of Corruption Act. The same act further says that public authorities, before we file or before we start the investigation or before we start the prosecution, we have to first get sanction from the competent authority, so that false cases are not filed against any public authority, right? So if a case against a public authority has to be filed, before that a competent authority shall be giving sanction for it. Generally, competent authority is that authority which is the appointing authority for that particular post or for that particular official. So the question in front of Supreme Court was, firstly, whether the judges of Supreme Court and High Court come under the definition of public authority or not, and if yes, who will be the competent authority to give sanction, right? Now here the argument of government was that judges of Supreme Court and High Court, they shall also be coming under the definition of public authority, because government said under Article 361 of Indian Constitution, only the President and governors of any state have been given the sanction or impunity against any kind of prosecution, meaning no criminal case can be filed against either President or governors for any criminal matter when they were in service, right? So when they are doing the official duty, no criminal case can be filed against either President or governor. So the central government's view was that only President and governors have been given such kind of impunity, not the judges, and hence judges shall also be considered as public authority. Supreme Court here agreed with the view of government. Supreme Court said that okay, judges of Supreme Court and High Court will also be coming under the definition of public authority. The only thing is, we will make sure that competent authority is not from executive side, or competent authority is not the appointing authority. So meaning the judges, they are appointed by either President will not be the competent authority. Competent authority will be Chief Justice of India. So no FIR can be filed against any sitting judge of any High Court or Supreme Court till the time Chief Justice of India gives permission for it or gives sanction for it, and hence in this case also against Justice Verma no FIR has been filed. Only the in-house committee has recommended its report to or given its report to Chief Justice of India, which has been forwarded to President and Prime Minister. What Vice President now wants is, Vice President wants this decision to be revisited, meaning it should not be CJI, Chief Justice of India, who is competent authority to give sanction for filing FIR. So Vice President is of the view that let President become the competent authority. Judges should not be given such a very powerful shield in the form of Chief Justice of India, that no investigating agency is able to file any FIR against any judge. So I hope this particular case is clear why it is essential. This case or this verdict, it is essential for judiciary to maintain its independence. But what the Vice President is saying, that through this judgment, what Supreme Court has done is, or what judges have done is, they have ensured that they are not accountable for legal system, right? So they are saying to hold the judges accountable, this case should be revisited by Supreme Court, and let, in place of CJI, let somebody else, let's say President of India, becomes the competent authority. I hope this case is clear to you, or the tussle between the executive and judiciary is also clear to you. Thank you so much for watching this video.